petition number 163 of 2019.
Sorry, we are starting a bit late because we realized even a mention of petitioners 3. We are informed that the petitioners will not be informed. There is Mr. Chair, are you going to any of the petitioners? Or you're one of the petitioners? Okay.
Could I do the representations?
Yes.
For the petitioners, you have the third petitioner in person, Mr. Charles Omboko. Yes. Then for the first respondent, Ms. Kamande and Mr. Ogoso. Second respondent, myself and Ms. Dom. Third respondent, Mr. Mwendwa. And then you have Mr. Ogoso holding brief from Mr. Angaya for the fourth and fifth respondents. Sixth respondent is Dr. Nyauni. Then for the interested parties, the first one has never appeared. This is the Council of Governors. Second interested party, Katiba Institute, is Mr. Chia. Third interested party, LSK, Ms. Muteni. Fourth interested party, Child Welfare Society, are they? No, they're not. And finally, for the fifth interested party, Communications Authority of Kenya, you have Mr. Kilonzo.
To give directions today, because we intend to finish the hearing for the consolidated petitions today. In our last ruling, we have getting the right to give a hearing date for petitioners. Now, Ms. Paragon, you indicated you might come to 5 supplementary submissions in once.
Yes, my lady, that's a possibility, particularly after we conclude the evidence this afternoon.
So we would like to give those directions now so that to file them to be deadlines, and then the petitioners can also file them in supplementary submissions in response. I'm being asked whether to be the other way around, since the petitioners have not indicated they want to file supplementary submissions. I thought maybe then the respondent would start first, and the petitioners, if they wish, they can file submissions with that.
Or will the petitioners have any position on supplementary submissions?
Yes. You find the
petition.
Yes. Yes.
So that the way that the response find out the minimum part and response to
because we had already filed, all the parties have filed submissions.
Yeah, we could say we could have, say, what, 14 days to put in supplementary.
We're actually thinking of 3 days.
3 days, really?
Yes. the petitioner they want to file supplementary submissions. In reply, they cannot work with it.
Could we settle on 7, my lady? We've been here for about 7 days and our other dockets are really suffering. We are under intense pressure.
That is going to now, Mr. Regalo, first of all, Justice Mogi will be telling for her leave days. She's actually supposed to be on leave. So she came back just to clear this two part. And secondly, the only days we have between the three of us now take submissions. So we are working backwards from 45. After that, someone will be out of the country, others will be engaged in
So the hearing will be either 14th of June.
Yeah, for petition 163,
Yes,
we are for 54.
15th. Okay. So working on 10th is public holiday.
That's why we settled on three days for each time.
Okay, 3 working days.
Yes.
3 working days, so Friday, Monday, Tuesday. So by Tuesday, the
Yes. For your supplementary submissions, then the petitioner will wish to apply and file.
between the 9th and the 11th. Yeah. We just have to burn the midnight oil.
So, Mr. Mo, for those 3 days are enough for you. So this applies to the respondents and the interested parties who are opposing the petition. We have 3 days, and the petitioners and interested parties who are supporting the petition have 3 days to reply with the supplementary submission. As the respondents and interested parties opposing the petition have entered into write and serve supplementary submissions within 3 days of today's date. And the petitioners and the interested parties supporting the petition shall, if need be, file supplementary submissions quickly in reply to respondents of supplementary submissions within 3 days of service, hearing on 15th October 2019. So that is for petitioners.
Most obliged.
My lady. How is
Yeah.
How is this?
Yes, I'm just being reminded that there were directions given us to the hearing which will apply, including the timelines for highlighting submissions. So the parties for once to be those are not participating in the consolidated petitions.
Thank you.
So the consolidated petitions, the appearances are as
Which for the petitioner, before that Ms. Munga is by 4 interested party and also who is Mutemi for the fifth in the morning, and Ms. Joroge is for the 6th, holds brief for the 4th interested party.
for the respondent.
For the respondent, Mr. Du has since joined me for the second and third respondents. Mr. Nyamodi is now here as well for the 4th and 7th. And Ms. Commander for the first respondent has been joined by Mr. Ogoso. And Ms. Dom holds three for Mr. Omuganda for the 8th and 9th interested parties.
Yes,
I started the examination.
yes. Yes, Jerome, could you please take the witness box? You're still under oath. We will ask you a few questions in the examination. You have all the documents with you? We will ask Mr. Oekwa to donate to you a copy of the amendment so that we don't have to. Okay, let's start. Mr. Chen. This morning, are you with me now? Yeah. Okay. This morning, Mr. Waikwa put it to you that because of your role in government and your training, you have an apt understanding of the NIIMs system. That's true? Yes. Could you kindly briefly describe how the NIIMs system works?
Thank you very much. Okay. The NIIMs system, first of all, I want to mention that the idea of having a single source of truth as government is something that goes back as early as 1989. Yes, the concept of a centralized database with distributed access was foreseen, and it was very important that actually all this information is brought together. So with that in mind, therefore, there has been really a lot of conversation, a lot of reports have been done, a lot of research in this particular area. So just now to bring home, beginning of last year, there was really great effort toward the establishment of the needs of the system, arising from the various challenges we have experienced as a country, because the issue of identification of citizens was really important, more so as a security issue. Therefore, in February 2018, a CAB memo was released, actually confirming and authorizing the establishment of NIIMs as a system. So the system basically was supposed to, we are supposed to come up with a system that provides us a single source of truth, whereby we will collect various databases, bring them together, and have a single key that would identify as the Huduma number, which would be a single source of truth. From the development perspective, in technology, we have normally about 5 or 6 steps under systems development. First, you go through your analysis, systems analysis, feasibility studies is done, and all this has been done because we have documentation available about the various systems that we are looking at. Then we move to the second stage, which is basically planning and designing of that particular system. And this was done by our own internal capacity. Then we move to the third stage, which is development. This is
you please repeat the first two.
the first one is systems analysis or feasibility studies, or sometimes referred to as requirements gathering. Whenever you're coming up with a system, you do a requirements gathering. Then the second one is planning and designing of the system. Then the third stage is development, or what is also described as programming or coding the system. So based on the design, you code the system, basically using programming languages, that now takes you to real development of that particular system. Then fourthly, we go to a very important stage under system development that is called systems testing. This is where you expose the system to all sorts of threats, both internally and externally. So this is where we invoke our hackers to expose the system to all sorts of threats, and that's where each comes like penetration testings are normally done. You assume to be cyber crime hacker outside there to try to poke the system by trying to go through the system through other windows. Then the fifth stage, we move to the deployment or implementation of the system. And finally, we have a stage that is normally called the system solution. This is a continuous process of any one particular system, because you continue to maintain the system, you continue to upgrade the system. If there are certain vulnerabilities that arise in the process of operationalization of the system, this is continuously done. All this within in the NIIMs system. So basically, to respond to a question that has earlier been mentioned about our architecture, we have a three-tier system that talks about first stage. We have the data or the server level. Then we have the application layer, where that is where you interact with the system. And then we also have the user. And that I have explained.
This particular witness refused to share the architecture in cross-examination. Can he now share it in re-examination when we have no opportunity to discuss with him? Even when shown that he had shared the architecture of Estonia, he was still adamant that he would not share the architecture and thought it was risky. So why is he sharing now when we cannot examine, cross-examine him?
With the profound respect to Senior Counsel Aadhaar, I don't understand the witness to be sharing the architecture. He is actually speaking on the data protection structures that were extensively discussed in the morning. And what I hear him to be saying, he actually said in the morning, there's nothing new in the three layers of security. The witness is proposed. There's nothing new. It's not yet talking on the architecture. We will get there.
For purpose of clarification.
I remember that that was the response to a question that was asked by Mr. Wen.
Yes.
Thank you. Just finalize that element of explanation on the three-tier protection available for U0 and for our.
Just before I go there, and also just for the purpose of clarification, what I shared was standard systems development life cycle. It is not the capital. Steps taken whenever you are developing. For the purposes of our three-tier system, like I mentioned earlier in the morning, we have the server layer, which is the database layer, or the database sits. Our system has encryption at the database level for the purposes of security. Then we also have the application layer. The application layer also has encryption. And even at the user access level, what we are saying is that correspondence between various databases is taking place in an encrypted form. Why is this important? the importance of this is that using technology, if your data is shared between various databases in, you may use the word naked form, it is easily interceptable. But the idea behind encryption is to ensure that whenever you are sharing data between respective databases, nobody can intercept the data while on transit. So it's very important that you mention that there are very many levels of security that you are putting in place. Beyond that, the system itself provides what we are calling an approval hierarchy. What does approval hierarchy mean? That there are various levels of authorization, there are various levels of authentication, which any user within the system has to go through. Let me break it down a little bit. For example, if it is in a banking environment, there is that person who we call the teller, who you interact with. That person within that particular system can only access up to a certain level of information about your account. Then there is another level in the bank where we have a manager. Again, a manager now has a bit of a higher level of access to your data. And that kind of architecture is what we have employed in the development of our system.
Okay. I want to post Mr. Waikwa asked you whether you developed a prototype of the NIIMs system before the rollout. And he put it to you that this would have aided in checking out the penetration risk. Did you undertake any penetration tests on this?
At the testing level of the systems development life cycle, I said we exposed our system to all sorts of threats internally by using our own team. And basically, in fact, some of at the design level, some of these threats we even enumerate that I am trying to do this. There is a whole record of some of the tests that are done. Having done that, we took the system through what we are calling, we did a mock launch of the enumeration. This actually happened now. Our mock our piloting of the system took place between 18th to 22nd February. That was way before we did the full rollout. Why was this important?
When did you do the full rollout?
The full rollout was done on 2nd of April 2019. Piloting was done on 18th to 22nd February of 2019. And this piloting, I want to confirm, was done in 15 counties, which includes 40 sub-counties. We have 40 wards and 40 locations. The idea behind this was to test the system before the full rollout. And that is where in our cycle we have that testing phase. During the testing, a lot of vulnerabilities also were discovered by the team that went out. So they came back, and through programming and coding, the vulnerabilities were rectified. So the essence of that was to test how the system would look like in an ideal environment, and which we ended in February 18th to 2020.
Now, for the last 7 days, we have heard about fears that the system may compromise the data, the system may lead into intrusion into private data of the citizen. Now, could you explain to the court what it is you have done to mitigate against this fear?
Like I mentioned, One of the things that we have done is introduction of an approval hierarchy within the system or access rights being provided at different levels. That is one of the actions that have been taken so that we cannot have one person being able to roam around in the system, right from the database. Basically, the idea behind that is also to segregate duties and responsibility. Secondly, the system has a robust audit trail. The audit trail is able, or within the audit trail, you are able to see as a system every activity that every user or any person who interacts with the system does. For example, if I get into the system and change a particular field in your data, that will be recorded in the system. And that is what we essentially mean by an audit trail. The time when that was performed, the user who performed, and the credential used to perform that particular transaction in the system. So in form of audit trail, that is available within the system, and we are able to monitor all that.
That then brings me to the question, again, over again about, is the NIIMS system centralized or decentralized?
The NIIMS system is, like I mentioned, is a hybrid of a centralized and a decentralized system. Let me explain. Within the three-tier system, we talked about at the bottom there, tier 1, we have the database. The database is centralized, and we have a centralized database. But then there are functional users who are outside there, and the functional access to the system is decentralized. To explain further, and actually to alleviate a fear that was raised, and I think I probably responded to it, but I will emphasize it now that I have the opportunity to explain. Take two examples. We have KRA accessing the NIIMS database. The user from KRA will have access to data only relating to tax. NHIF, the users at the NHIF will have access to data only associated to NHIF. Does KRA access NHIF data? The answer is no, because there is no that linkages between direct linkage between KRA as a functional user and NHIF. So as we talked about distributed, centralized terms of database and central repository, it's important to have it in that particular format, because again, when we talk about a single source of truth, we want to maintain the sanctity of that single source of truth. If you expose yourself to an opportunity that anybody else can update that single source of truth, then it ceases to be a single source of truth, because everybody else will be able to alter that particular data. So that is controlled to that extent. And again, understanding the distributed responsibility of the various government agencies, each one of them has their role, and each one of them have access to data to the extent of what their mandates are as either a ministry or a department or an entity.
Let me put it this way. If you access a functional database, are you able through that to access laterally another functional database? Is there a line? Look, this is the center, this is KRA, this is NHI. Can they speak to each other without coming to the center?
No,
understand?
That's what I was explaining.
Yeah.
They can only have direct access to the database, because the control is that they will have access to the extent that information only concerning them. So KRA cannot look at NHIF data, NHIF cannot look at NSSF data, and so on. With all that.
Now, you were asked whether, for example, you have spoken of the pilot registration membership. Was there a report generated from that pilot?
Yes, there was.
Now you are asked whether you share that report with the public.
We did.
Why did you not?
Because we felt, again, for security reasons, that we will limit ourselves, because when you come up with that report, what does it show you? It shows you the vulnerability of your system. Therefore, you don't want to again continue exposing that vulnerability to anybody else. You work with it yourself inside and rectify the vulnerability that you have discovered. So and from a system perspective, it's very important that these are controlled documents. Anybody, gets me back to my college days, those who are really controlled documents, as whoever you do your test, vulnerability test, put it in a file, very controlled document.
Now, some issue was raised with respect to the procurement of the devices. And I know you say devices, yes, the hardware utilized in the registration. And you say it was a restricted tendering, is that so?
Yes.
Why restricted?
Again, also, when we talk on behalf of the procuring entity, because in this sense, the procuring entity is the Minister of the Interior, looking at the sensitivity of the system. For security reasons, we thought it would be important that it is closed it is treated as a restricted tender.
Who eventually won the tender, just for record?
The IDEMIA system.
IDEMIA system. What else other than devices has IDEMIA supplied in the news?
The IDEMIA only provided us with the devices. Beyond the devices, all the other software was developed by our own people, my staff.
Your staff developed the software?
Yes. When I say my staff, is the multi-agency team that we put together.
Now, Mr. Waikwa again asked you a question on the concept of the single source of truth. Could you please explain that better? What is it you mean when you talk about a single source of truth?
The single source of truth, and to refer to the broadly used practical examples, is that as we were looking at the NIIMs, the argument has always been that we have multiple databases that, one, do not talk to each other. With all these multiple databases, some of the data also is not being data. So we are going to take this opportunity, one, clean the data, and secondly, come up with a database that is going to be authentic. How are we going to do this? We have all this data in manual form. The idea behind NIIMs was digitization of the existing manual data, one. Secondly, bringing on board an identifier which we were bringing on board through the biometric data. In this particular context, is the fingerprints that we were capturing during the enumeration period. The fingerprints captured would then now help us generate now the unique identifier after going through the cleaning process.
Now let's move on to another area briefly. The data protection policy. Please look at page 110 of your affidavit number 5. The big in that, from page 110, you will find the data protection policy. 110.
Yes.
Are you there?
I'm there.
Now, incidentally, just so that the board understands where we are coming from, that data protection policy, it says data protection policy 2019. Is that so?
Yes, it's right.
But it has been put to you that the process of developing NIIMs started way back from early 2018.
Yes.
What explains this date 2019? How do you explain it?
The policy on data protection?
The 2019. You understand what I'm asking? Did the data protection policy precede the development of the NIIMs?
The development of the NIIMS system actually started when the CAB memo that was issued.
CAB memo, you mean cabinet memo?
Cabinet memo that was issued in April 2015. The cabinet memo issued in 2015 from ministry perspective on how government works in itself is an authority internal that we can actually begin a process. Therefore, based on the CAB memo of 2015, we engaged, actively now brought on board all the stakeholders, and actually that responds to my letter of the letter that was actually, I think it's May, the letter that was actually calling for the interministerial task team to begin meeting, because once the CAB memo had been passed, then basically we were going to get into action in terms of developing the new system. But moving forward, backward a bit. By the time you get to that CAB memo being passed, we normally go through a lot of internal processes. So, as it says, 2019, yes, but really the process of preparation of the CAB memo started way back earlier with a lot of consultations and all that. But the date now is when the CAB memo was actually approved. So, to answer the question, that actually the development or the discussion around the development of the NIIMS system started on the strength of the cabinet memo that was issued to us.
Now, look at that data protection policy on page 112. There, 112 or 112, there you will find an introduction to the data protection policy. And Mr. Waikwa had you read paragraph 2, 3, and 4 of the introduction, just so that we get the context of my question now. Could you read the 4th paragraph that starts the government of Kenya?
The government of Kenya values the privacy and the protection of personal data. All the actors involved in the management of personal data are expected to respect the requirements of safeguarding personal data. Through the Constitution, the government of Kenya is committed to protecting the privacy of individuals. The government recognizes that this protection is an essential element in maintaining public trust in entities managing personal data and essential for the social economic development of Kenya in the fourth revolution.
So the key words here are privacy and the protection of personal data. Yes. I ask you the question. In the development of the NIIMs system, are you satisfied that this was obeyed?
Yes. In the development of the NIIMs system, we have taken care of privacy and protection of personal data. And like I said, that through encryption, data is transmitted in an encrypted form, which basically or essentially safeguards against interception of data. Secondly, data is only visible to those who are authorized to see the data based on the system's access rights and also approval hierarchy.
Good. On that, finally, you are asked, there is a statement on page 112 that says on paragraph 2, personal data is a critical resource that drives economic growth and development in this country, as oil was in the past. And so I will ask you the question, do you think this is a proper analogy? Is it proper to analogize personal data to oil, and why?
Yes. It is proper that we are actually saying oil data is equivalent to oil. And I'll explain. The fourth industrial revolution is based on technology. At the heart of this technology is data. Therefore, it is very important and it is becoming more critical that data will be helping us in solving many of our problems. Data will help you in decision making. We want to make decisions based on facts. For example, when you're talking about agriculture, for you to be very sure about the kind of crops you want to plant in an area, it's only good data that can guide you towards that direction. When you want to make decision about the number of schools you want to build, it will be the correct data that will guide you into what is the population of that area. So when we talk about data, we're actually talking about information that is going to help us in decision making, and it is very critical. So when we talk about having data as the next one, you will find data sits in a position. One, as we have this information, we are actually talking about the ability to develop many other applications that would even help us create employment. The essence why we are talking about the single source of truth is that we need, and maybe just so that I combine this two statements, data will only be of value to you if you have genuine and accurate data. So, as we talk about the single source of truth, we are actually talking about data that is authentic, that is reliable, and that actually can help us in decision making. So, the analogy about the use of data and oil to be sound in the sense that it is going to drive the next generation of technology development. There are a number of technology developments that we are going to do. We talk about Internet of Things. Internet of Things is about data. We have data being collected everywhere and every time about everything. But then the most important thing is that you collect that data, make analysis of that data, and it will help you in decision making. I was looking at it from that perspective.
Thank you. Now go to page 100 and page 1 of your panel. And the bigger bit 100 page 1.
Oh,
the short analysis. Are you there?
Yes.
The SWOT analysis? Yeah. Let's start at the beginning. How was this SWOT analysis conceptualized? Who, for example, was the driving force behind this study?
Yes, like I mentioned at the beginning, that there were a lot of research, a lot of investigation going on how to implement single source of truth. There was need to basically continue in this line of fact finding. And one of the things that was coming out key was the issue of how do we collect data, and more specifically for children. So, due to our budgetary limitation, we engaged UNICEF and actually requested if they would support a study as we intend, because I said this idea of going towards a single started all the way in 1989, and we have just been trying and also studying, and the more reason why there are so many benchmarking to just get right footing. So we engaged the UNICEF and requested that now that we intend to look at children's data, please help us with the research in this particular area. So to answer your question, it was a ministry-initiated exercise through partnership with UNICEF.
Go to page 10 of that report. There you will find the records of summary. Page 1000 and page 10. Please look at paragraph 2 of that page. It says the overall objective. In other words, please tell the court what was the objective of that.
The overall goal of this report is to compile a comprehensive, analytical, and in-depth strength, weakness, opportunity, and threat analysis of the existing identity registration system in Kenya.
Correct.
Considering current ICT-led government practices, birth registration coverage is predominantly manual. This report will address obstacles and gaps and compare them with global good practices.
Now, if these report have any recommendations, please look at paragraph page 12. Page 12. Under, I think there is recommendations. What is the second bullet? Recommendation.
Formation of a steering committee to coordinate and design the system.
What system are we talking about?
We're talking about the registration system.
Look at the last bullet on that page. Right? What is one of the long-term recommendations? What was it? That's the bullet. That's what I'm interested in.
Design and operationalize of the unique identification.
Okay. So one would be right to conclude that the Huduma number or NIIMs system was really approved, was really a recommendation from this study?
Yes.
Now, you were asked the question, who are the participants in this study?
Yes.
Who are the participants?
The participants in these studies, from my understanding, came from government with the various registration institutions, together with the technical ICT, also together with the UNICEF team.
Together with the UNICEF team. Let us move briefly to another area. Maybe bringing me to, let's look at the Statute Law Amendment Act. I'm interested in
Which document?
I'm interested in amendment 9A. What we gave you, the last one we gave you.
The one we borrowed.
Yes, I think it was a nation. 9A, do you have it?
Yes.
Now, the question I have for you on this amendment is to clarify an issue. Could you please read 9A1? What does it say?
There is established a national integrated identity management system.
9A to B.
To assign a unique national identification number to every person registered in the register.
What do you call this unique national ID number?
That is the Huduma number.
So then, it is evidence that the Huduma number process and what you would call function. One of them is to assign a unique national ID number, which you say by communication you go to the
Yes.
Now, again on the functions, will you please read out 9A of the system?
The preservation, protection, and security of any information or data collected, obtained.
So then, 9A of the Registration of Persons Act also provides for the preservation, protection, and security of data. That's all.
Yes, it's that.
Now, quickly, let's you are taken to the affidavit of engineer individual, specifically paragraph 43. Could you go there, please? In one sentence. Are you there?
Yes, I am.
Under that paragraph, engineer individual says some of the benefits of the NIIMs would be of engineer individual. From the NIIMs project.
Yes.
Again, quickly tell the court how would this institution listed in paragraph 44 interact with NIIMs?
The various institutions that are mentioned here would interact with the system based on access rights. That you would have the judiciary, for example, having access to the system based on their functional responsibility and the access rights that the system's administrator will provide. So to answer your question, it is based on responsibilities, functions, and access rights that will be provided.
Good. Now, again, just to clarify, these institutions will not talk, so to speak, to each other directly.
No, there will be no cross. To be very specific, each institution, I repeat, will only be having access to data that they are responsible for, or that belongs to their function or responsibility.
Would this interaction pose any risk to the system? Would the fact that these institutions are using the information in the NIIMs system pose any risk to the data?
No, to the extent that we'll have put requisite security control and measures.
Now, again, my learned friend, Mr. Owaiko, asked you, in the development of the NIIMs system, did you consider any alternative?
Yes. The fact that we were able to do the benchmarking, this was a fact-finding issue. Our objective was to see what are the other systems outside there. The benchmarking provides an opportunity for us, an opportunity for us to be able to see the other systems that exist, and based on the environments that those systems were operating from. So yes, we did.
And just again, in a few words, which countries did you benchmark on?
There was a benchmarking in Estonia, which was one of the countries. And I would also want to mention that the Estonia is, because it's the only one that has actually been captured here. In our journey towards this implementation, there were even other previous benchmarks. It was as early as 2015, as early as 2014. A couple of other countries were visited, because this, like I said, has always been a force in government in how to implement it.
Now, something I've just forgotten, I'm reminded on these, it is a concept, is it a name, is it a phrase you have adopted, Huduma number, and you say it is a communication concept.
Yes.
How do you arrive at this, and what is the utility value of it?
The Huduma number name basically was a communication concept to simplify what, to make it easier for Kenyans to understand, as opposed to what we were struggling with in the morning, the National Integrated Identity Management System translation. So basically, just like the way we normally say our identity card comes from, we looked for a phrase that would easily be understood by any other Wajiko or a TNO or whoever is outside there. So basically, that was the thinking around it. But with that particular thinking, as in terms of simplification of communication, we knew very well that we are talking about me.
Now, it was put to you, if I recall correctly, that the use of the word Huduma number was sort of like mentioned for us the system. If we don't register, we don't, Huduma meaning service. You don't register, you don't get a service. Is that so?
That was not the thinking at all.
Now, the council, Mr. Waiko, dwelt a lot on the, if you go to your affidavit, please. And I want to refer you particularly to paragraph 44 of your affidavit number 5, the big affidavit. Are you there?
Page, sorry,
Page 9, paragraph 44.
paragraph.
Could you please read that paragraph, the beginning of it?
That I am advised by the fifth respondent's advocate, which advice I verily believe to be true, that contrary to the allegation by the petitioner that there are no data protection rules in Kenya, there is already in existence a wide array of statutes and policy providing for policy for the protection of privacy and the general integrity of ICT systems and information.
No, just pause there. Mr. Aiko gave you what we call the long title, the preamble to this statute that you cite here. Access to information, TICA, computer misusers, and cybercrime act, and sought to get you to say that these statutes do not apply to data held within the NIIMs system. Is that so?
It is not so. Because from a layman perspective, as I read those, let me just pick one of them. Each one of them was always ending with connected purposes. To my understanding, would be any other related law. That would be my interpretation of that.
The question really is we have before the House now a data protection bill.
Correct.
Question is this: do we have a data protection bill, possibly looking forward to a data protection act, because there is a lacuna in the law on data protection?
The answer is no. That the data protection bill or the data protection policy that we developed, that subsequently led to the preparation of the data protection bill that is currently in Parliament, addresses all aspects of policies relating to data protection on ICT, but not limited to NIIMs only. So that particular piece of legislation is going beyond NIIMs because it addresses so many other issues related to data protection.
Now look at page 15400. Page 15400. That is the data protection bill. Part 5, as you see. Yes, part 5, the broad title, grounds for processing of sensitive personal data. And the question was put to you in the absence of this provision in the law, okay? What are you relying on for the processing of personal data now held?
Just thank you. I think I got it okay. Just repeat again.
Are you on page 154?
Yes, I am.
That's the data protection bill.
Right.
Look at part 5 with the broad title, Grounds for Processing of Sensitive Personal Data. You see that?
Yes, yes.
And you were asked whether, in the absence of this, I'm paraphrasing, in the absence
Yes, yes.
of this being law, what legal framework are you using in the processing of personal data?
I said we are also currently relying on the Access to the Information Act.
Yes.
And the KICA Act, and also what has been passed, the Computer Misuse and Cyber Security Act.
Look at page 156 of the document you're holding, 2 pages ahead of you. Transfer of personal data outside Kenya. Again, I pose the same question. In the absence of this provision, what are you relying on in processing the transfer of personal data outside Kenya if required?
Again, those 3 laws that I mentioned, the KICA, the Access to Information, and the Computer Misuse.
A very preliminary question I think that we should have dealt with earlier, but I want to ask you now, because this was brought to your attention. If somebody does not have an identity card, then they register the new system.
Yes, they would register in the NIIMs system, but there would be an indication of X, like the instruction to our given.
What does the XX mean?
The XX will essentially mean at the point of data verification and validation to the systems programmer. That would mean that because let me explain. We noted that there were a number of reasons as to why somebody would appear for data enumeration and biometric data capture. There would be a number of reasons as to why somebody would not be having an identification card.
For example,
the card could have been lost.
Yes.
The card could have been damaged, mutilated, and they are in the process of getting the new card. So, at the at the point of data cleansing and issuing Huduma number, these are the records that would actually cross-reference and request if that information has since been made available for us to be able to capture them into the system.
So that the XX, the design of the system, for those who don't have an ID, is not really an exercise in exclusion by design as possible.
No, it was an exercise for information. In other words, you take note that there is missing documentation.
Now, let's go to the practical example that was given to you by Mr. White. A policeman stops you, suspects you are over the limit, stop speed. Suspects you have taken more alcohol than hypothetical than you should have, you're driving, and he keys in your Huduma number. Does the system indicate why, for example, the policeman stopped?
No, the system does not indicate why the policeman stops you. When a policeman stops you, the policeman would be requesting for particular information, the identity of this particular person. If it is something relating to traffic, the policeman would only be getting information of age, valid driving license, as to ascertain or whether you really should be on the road. Like I said, we will be providing functional access is that respective users will be having access to the system to the extent of their responsibility as government officials. So the policeman would only be wanting to know whether you have a valid driving license. For that reason, the system will only reflect to him or her, for that matter, whether you have a valid driving license. There will be no information sent about your tax compliance because that is not what he's looking for.
Finally, Mr. Waikwa, on that issue, made the statement that the petitioners are not opposed to utilization per se. Understand that?
Yes.
They don't say don't speak, right? The petitioners think that the system is designed to exclude, for example, the petitioner number one, the Nubian community, and the maybe breach. Now, my question to you is that, first of all, let's start at the beginning. As an IT person, is there an electronic system that can be said to be 100% good?
No.
Now, starting from there, and with your knowledge of the NIIMs system,
Yes, I would want to commit that taking into consideration the design of our system and all the measures that we put in place, we have endeavored to ensure the privacy and protection of all citizens' data. And secondly, using the technologies that we have, and I want to mention Kenya is well positioned in terms of the development of our ICT. For example, one of the things we have done and we've been doing is that in terms of security of data, we have established what is called a SIRT, S-I-R-T or S-E-R-T, Computer Incident Response Team or Computer Emergency Response Team. These are a team of experts whose sole responsibility is to monitor any threat to our systems. And not only the NIIMs alone. Nowadays, government is almost going to full automation. There is a full team of experts whose 24-hour responsibility is to be monitoring stuff. And I wish to report that even at the point when we were actually implementing our NIIMs, there were numerous attempts. There were numerous attempts to infiltrate the system, and these were all faulted. In fact, we had to just have to go out. Some of these security actions are normally you evacuate your database to a separate position and keep that hacker very busy hacking something that really does not exist. So these are some of the techniques that we're able to use. But then to answer your question, all systems are always in constant threat of attack. And as a ministry, we take cognizance of that fact. And we are putting into place, and we already put in place measures that will be safeguarding our system.
Moving a slide ahead to Madam's friend, Mr. Will's presentation, an inquiry was made of you as to whether biometric may be manipulated, and your answer was yes. Correct? Now, what have you done to guard against any such possible
Legacy system. In the NIIMs system, and I think that also relates to a question about the extent to which you are collecting data. Biometric in itself, in terms of deduplication in technology, we say it is probability that you have a certain degree of extent to which you can positively confirm biometric data to relate to a particular. But then, in our NIIMs system, which is quite different from the other systems that had actually been mentioned, is that we've gone ahead and tied together the biometric data with other identification data. To a very good extent, an ID is equally a unique identifier. But then the IDs have been abused because the fact that I hold an ID does not necessarily mean it belongs to me. So we've combined two issues whereby you are combining the identity card number to the biometric data to improve now your extent of deduplication and actually move from probabilistic to actually deterministic. And coupled with all other strings, if you continue increasing the number of data you attach to that particular data, then your levels of confirmation gets even higher and even better. And that is the model that we've used in deployment of
good. Let's highlight something else a little bit perhaps. You are shown by both Mr. Waikwa and Mr. Wele the fact that discussions on NIIMs probably started in early 2018. In your letter of May 2018, inviting the interministerial, is it a task force? Remember that? Right. The fact that the presidential assent to the miscellaneous law was on 31st of December 2018. Yeah. And the fact that the data protection bill dated 2019. Remember that discussion?
Yes, I do.
Okay.
Yeah.
How do you explain this train of events?
Yes.
What should have preceded the other and why?
Well,
or why not?
I explained that we had a cabinet memo that was approved in April 2018. Whenever cabinet memo comes out, there is always a letter coming from the head of public service, bringing to your attention that particular cabinet memo, and there is always a statement to take necessary action. So my letter inviting people or the formation of the technical team was the beginning of the necessary actions to be taken arising from the approval of the cabinet memo. Because the cabinet memo of April 2018 had, through cabinet, established the need. Then thereafter now, we started the issue of discussion about bringing on board all the agencies that were involved, the NIIMs, KRA, to begin discussing the implementation and deployment.
Maybe this is flogging this issue much too hard, but let's just repeat it again. What I suppose that you were asked by Mr. Wele as to whether you have complete confidence in the security of the system, and your answer was yes. According to you, yes, you have this confidence. Why don't you put into the public domain the design and the architecture of the system? Now, could you explain to the court why you have that?
The design of the system, like I said again, is really an internal aspect, and we are actually not going to expose the design of the system to the public for security reasons. The documents that we saw about the Estonia.
We are going to just finish the answer to this question. I'll take it. Yeah.
So yes, the design of the system, we are not going to expose it for security reasons.
Okay, look at page 227, page 228 of your affidavit, I believe, affidavit number 5. There is a pictorial representation of the system architecture of Estonia.
So let me just say that 227.
227, handwritten, and 228. First of all, are you there?
Yes, I am.
227, 228.
Yes.
In those 2 pages, do we anywhere see the algorithms of the Estonian system?
No.
Would you say that what you see in 227 and 228 is the architecture of the Estonian system?
This is a representation of the general architecture, but this is not the design of the system. It's just like, can I give an example so that we are all clear? When we launch buildings, we normally see something like the architectural plan of the system. I mean, of a building or an installation. That thing you do with mud or whatever. Basically, that would be a representation of this kind of system, which basically tells you nothing about what that system is all about.
At this point, I think when you were explaining, you spoke of source codes, and I think Mr. Wede was copying. Okay.
Yes.
You were explaining about source codes and this kind of thing. Can you explain to the court the difference between that source code and what we are seeing on 228 and 229? 227 and 228.
The source code is the heart of any application, any system being developed. And that really is the heart of whatever application that you have, because it is really the program. Remember when I said we actually developed, we moved from analysis, design, after design we have development. At the development stage, that is where now we really write the programming code that runs whatever system that we're going to have. A source code to just say when somebody logs in and you accept is normally something like half a page. So a source code of a system like NIIMs would be something like this, full in terms of the programming that goes on into developing a single application. Therefore, this cannot be anything near a source code.
In your experience, is it usual, is it common to have programmers put in the public domain the source code for their systems?
Yes, under what we call the open source. There is a community of programmers outside there who do programming for fun. Therefore, they will develop a program and actually put their code outside there. You may want to use it, you may want to adopt it, and yes, they are out there. But it also depends on the sensitivity of your system. We would not use an open source code for the development of this system.
What would you call the NIIMs system code?
The NIIMs system code is proprietary. That is our own source code that we have developed, and not open source.
Now, I think it's Mr. Awede who took you to the report by Mr. Brian Mwenga and asked you about the recommendations on certain principles on design and architecture that were made by Mr. Mwenga, Brian Mwenga, who was your witness. Okay? I ask you the question. To what extent does NIIMs comply with Mr. Mwenga's recommendation?
There were numerous recommendations by Mr. Mwenga, and like I said, there are recommendations, and we were only not limited to Mr. Mwenga's recommendations. So I would say that we did not fully comply to Mr. Mwenga's recommendations. Those ones that were found to be good were adopted. Those ones that we felt we could not implement, we did not implement.
But the recommendations as to data protection, did you implement them?
Yes, the recommendations as to data protection, and like I said, our interest in terms of ensuring that our data is protected is very key. So all issues relating to data protection are key to us, and those ones we did pick up as applicable recommendations. Implemented.
My ladies, my last 5 minutes. Please quickly go to page 2.1 of the graphic. That is the McKinsey report. Page 2.1, the third bullet. Okay. You are referred to that by Mr. Whelan. Capturing the value of good digital ID is by no means certain or automatic. I refer you to the second line that says, careful system design and well-considered government policies are required to promote abject mitigate risks, etc., etc. Would you say that the system that we have in NIIMs is one that has been carefully designed, taking into account all these details in the McKinsey recommendations?
Yes, sir.
Maybe talking about the Estonian experience, we could go to page 225 of your 100 page 225. Right? The summary of success of implementation of the unique pattern identifier in Estonia. Correct, eh? 225, 100 and 225.
Yes.
Can you see that?
Right.
Please read the first bullet under legal and the policy grounds. What does it say?
No new law formulated, but amended the existing law to incorporate the use of technology.
That is Estonia.
Yes.
Is that equivalent to what you have done?
Yes.
Again, the same report, please look at, now this is different. This we have me. Mr. Awele asked you why, he asked you, did you explain the risks inherent with collection of information to one entity? Did you do that?
No.
Why not?
we didn't go to the technical aspect of the system, like I mentioned, through our process of awareness creation. Our emphasis was more onto the use of the system and the reason as to why people would come out for data collection exercise. So our emphasis mostly was on that, and we didn't get into really the technical aspect of the system to the people.
Would you say that interagency, departmental sharing of information within government is a legitimate exercise?
Yes, it is.
Now, you were asked about regulation. You remember this?
Yeah.
For NIIMs particularly. Were there regulations that guided the collection of information?
Yes, I mentioned the act on the law that relates to registration of passport. So that was the act that we were relying on, and other related acts relating to registration of passport.
You wrote on the regulations made under the registration of persons, right?
Yes.
Now, is it true to say that nature of information being collected under NIIM is more sensitive than any other information held by government?
No.
Under NIIM, did you collect any new information?
No, except to the extent of biometric data.
To the extent of biometric. I mean, I put you the question. In your experience, sounds to me like all your life you work for government.
Yes.
Have we heard incidents of breach of electronic data by government?
No.
You don't know any incident that electronic data held by government has been breached?
No.
Finally, Mr. Waikwa asked you as to whether if the court were to order that you tweak the system and paraphrase Mr. Waikwa, you will be compelled to comply.
The exact place was redesigned, and then I added. So,
yes, can the proper question be put to them?
I thank you, Mr. Waikwa. I let's have one more line. Redesign. And he asked, would you comply?
Yes. I said we would comply because it is an order. But again, I wanted to put a rider that we would also wish to inform the good court about the risk that such a redesignation or a redesign of the system would occasion. And I think it would be important here to say yes, we would comply, but we would inform the court of the risks that would arise from that.
And what risk would that be?
The risk relating to security of the data, the risk relating to security of our system, and vulnerability of the system.
Finally, if the court were to order that you reduce the amount of data held, I think this was okay. Let us give you ID biographical, but not about the land I own and what I have. Okay? Reduce the amount of data held. Would that be possible?
To the extent of the order, we will comply.
What would that entail?
Sorry, okay, I think maybe we have
What would compliance entail? That's not my question.
of removing the data.
Yes.
Is basically reducting the data, or basically you would be having a data, but you do not have, I mean, we don't use it. Well, I think I would just simply say it would be very important to get what directives we will be getting from the court. And I'm imagining you saying, is it the court saying we remove the data, or the court saying we do not access the data?
No, the court is the question that was put to you, not my question. If the court say reduce the amount of data you host,
Yeah.
will that be done?
Yes, it is possible, because you simply delete the data.
Thank you very much, Maleti, my Lord, Senior Counsel Mother, looking at it. And I wish to stop maintain our and unless the court have a question, I'm done with it.
Now, we talked about the simple source of truth there. And then this question I'm just asking what to the so I'm just asking this out of curiosity, because you are talking of a single source of truth, and yesterday we were told about how this system is going to be very useful. I don't have to move from here to KRA, get my compliance certificate. I'm asking this one for the villagers. I've heard you talk about villagers, and I think you like the village. Now, we have our youths who normally they apply for employment, we are called, so go to the DCI, go to the ACC, move to KRA, and yet you have stayed the function of KRA cannot talk to the employing agency like the judiciary. That means the young man will still have to go to KRA. He has to go to ACC. Or you will talk to the master, to the center, and then judiciary will talk to the center. They are allowed to access KRA information about an applicant, for example. What will happen? The system will be able to give response to an individual citizen. If we are requesting for a tax compliance certificate
from my brother, then through the technology, we have direct communication to that particular citizen arising from this year. So this year I should be able to give, the system should be able to respond, giving a code that in terms of compliance, X or Z is compliant. And that particular information, the individual can carry.
Okay, I had a question. Now you say that if the court orders the system to be designed, there will be certain risks. But at the same time, you also told us that you put in place measures to ensure that there's no unauthorized access to the hierarchy of authorization. So with all these measures, where would the risk come from in redesigning the system?
Yes, I gave, and I think I want to respond to this one. When the question came as in, don't you think we have too much data? And I said, to the extent of the information that we are capturing, we feel we have enough data. Then the other question arose, I'm just building up so that I get to your question, is that is biometric a probabilistic or a deterministic? I said, DNA is a probabilistic determination, but coupled with other data, that is, if I combine your DNA and your ID, I begin now increasing my level of confirmation about your identity. So now, straight to your question. If, for example, in the process of redesign, we are requested to remove the ID, then I say that is the risk that we begin causing ourselves onto, because we are saying if we only remain with the name, then combining the biometric and the name, there are so many genomes in this country. Unfortunately, I don't think there are so many. There are so many Johns. There are so many Johns in this country. So if we're going to rely on combining biometric data and the name John, then we would have very many people with such combination, which basically does not give us good results, so to speak. That's the line of thoughts that I was talking about.
So the risk is not to the architecture of the system, it's to the authenticity of the data that we will get from the redesigned
Yes,
system.
yes.
Okay, I think that is all. Thank you very much for coming and for giving evidence. So we can release you now. Can you move the next speaker?
Yes, he will be out here. Malaysian court here on our will be an investment.
So while we are waiting for the witness, the petitioners have been talk about one because
We are still coming to the shortest time possible.
might be even less.
Not beyond 1 hour. It could be less depending on the. Maybe we're seeking direction after this witness now that we have not arrived. And looking at the time we have taken, also noting how many parties, petitioners and respondents are in the matter. Is it possible for the court to consider giving us opportunity to put in written submissions on what has transpired in the hearing, rather than oral highlighting, just to save the court's time?
I think when we give direction, we would agree that the parties should be given opportunity to file supplementary submissions. But if the parties are agreed, we can revise the directions and rely on the written submissions for that. But I just know that maybe they want an opportunity, which is why we've given that direction as to highlight. We've given some directions as to highlighting of submissions and time limitations.
If we are time bound, that can be possible. But otherwise, I was just wondering whether that also could be converted to an opportunity to put in further written. Also limited in number, if time is not available. I don't know what my learned colleague would say. We've just been wondering how to conclude.
Yes, for once I agree with my colleague here. In fact, previous directions had contemplated that after we finish the oral hearings where we did the tribute file and supplementary submissions, we wanted to crystallize the issue to make it easier for the court and everybody to deal with it. Could we dispense with oral highlights altogether? I doubt it. Lawyers always want to have 1 or 2 words to escort the written submissions.
Because what we agreed that after the hearings and arising from the evidence, the parties would have the opportunity to file supplementary submissions.
Yes.
Then we would highlight.
Yes.
So the parties are agreeable and the time limitations we are going to give are the same as the ones we just given, the ones in terms of supplementary submission.
Literally 3 days.
Yes. So that we can have this matter at if there is highlighting the time limitations. What the parties should assist is, since for the submissions we had allowed the interested parties to file submissions and highlight. If they are agreed, then they can just file one set of submissions for the petitioners and for the respondents and highlight just the petitioners to highlight and the respondents if they are agreed amongst themselves, so that we can save on time.
May I just suggest one more thing for the court to consider? I believe the difficulty of getting of the court indicating 3 days and 3 days is partly because you're aiming at the date of highlight. Could it also be a compromise then? That what we will, because I believe what senior counsel is saying, we would get directions as to when to file other submissions based only on what has transpired in the hearing. And then the court would actually give a judgment date. So parties don't come back to highlight all. So that the compromise then becomes that instead of getting the 3 days, which I think warrants again and would warrant me too, then there's slight flexibility because we don't have to be here on the 15th, assuming 15 is the date you get to in 163. Then we can be a bit more flexible. I think it's a compromise.
But part of the compromise is that we don't file the supplementary submissions serially, so that say the petitioners go first, then we respond. But we do it simultaneously because if we do oral highlights, then there is an opportunity to sort of cover any new issues raised. As to whether we should dispense oral highlights, the petitioners want to dispense. To the left. Could we consult for a few minutes then? Maybe at the tail end we can give our position now that the witness is here.
Yes, good afternoon. Please confirm to the court your name is Zoe Ford Brady.
Mr. Boledi, we are reporting to the proceedings, so you can turn off to the mic, the one that.
Make yourself comfortable.
Yes, Lord.
Your name is Zoe Ford Brady. Zoe Ford, your what?
Mr. Boledi. First of all, we are not lawyers, so we can dispense with calling us. So, just answer yes or no.
Thank you.
Thank you, Ali. Mr. Brady, you work as an assistant director communications technology in the Ministry of ICT.
Yes, I do.
And you have been authorized by the ministry to render an affidavit in this matter.
Yes.
Mr. Brady, what is your highest level of training? Master's degree.
Information system.
Where did you get this work?
University of New York.
Is it true to say that you have been involved in all the processes of development and establishment of the MINT project?
Yes, it's true.
And you have offered the details of your involvement in this affidavit that you have Finally, hearing, my ladies, my lord, an affidavit dated 14th May 2019. You have this affidavit?
Yes.
And this affidavit forms your evidence before court on this matter now. And you adopt this affidavit as your evidence.
Yes, I do.
Thank you. My lady, my lord, we all, Mr. Brady, I think you need to make yourself more comfortable. Maybe hold the mic, push the chair forward if you want, so you don't have to say something like that. Thank you.
Good evening, Mr. Mori.
Good evening.
Were you part of the benchmarking team?
No, I was not. I was not part of the benchmarking team.
Not in any of the countries you came from?
No, I was not part of the benchmarking team.
And you still maintain that you are part. You are at every stage involved in the development team.
Yes, in that I'm a consumer of the reports that came out of the benchmarking team.
Is that report, is that the report connected to the affidavit of Jerome the team?
Yes, it is.
I see in paragraph 5 of your affidavit, I hope you have it there. Is that right? I am thinking of, we had 2 mics at that stage.
And this goes on, we can try.
So just to reconfirm that, Mr. Murray, you have said you are not part of the benchmarking team. You have said you were not part of the benchmarking team. Okay, now it's working. You are just a consumer of the reports by the benchmarking team.
Precisely.
So the benchmarking team was not the same as the team that developed.
It's one and the same team, I would say, because they come from this.
But not the same individuals. We could be part of a larger team. Did any of the people in the benchmarking team become part of the process we say that develops the needs?
Yes.
Name them.
Robert Moore, Mary Kelma, Ruben Kimuro, and Janet Ugere.
Developing as in developing the software, because I understood you when you said you were part of every process. I thought, and you said in designing operational and functional architecture of the identity system, you go on to explain you did not cut and paste. Were you part of the design and development of the architecture?
I was part of the development of the architecture.
And the benchmarking team members, were any of them the ones you have mentioned part of it?
Yeah, part of
Developing the design and architecture.
the team.
Are you aware that they were able to receive reports of the design and architecture of the Estonian model, which is now attached to this affidavit of Jero. And we show this page 227 of the main Jero's affidavit. If you have yours, we show 227 and 228. You are a consumer of the report of the benchmarking.
Yes.
So you know this is the design that is displayed there.
This is the design of the Estonian system.
Okay, which the Estonians gave and which Jero now has displayed to the court and therefore to the public.
This is a report from Estonia.
Yeah.
And this is the architecture they have used.
Therefore, you will agree with me that there is nothing prejudicial in showing your architecture.
Let me say that the benchmarking is about learning the best practices.
That I understand.
So the architecture that we adopted for NIIMs.
I have not asked reached there where what you adopted. I'm asking you, is it fair to conclude that if Estonia could share their architecture, there is nothing prejudicial in merely sharing the architecture of NIIMs?
Mr. C, the high level. What we have here is a high level architecture.
Yeah, that's I'm okay with. Have you shared your architecture with this court? Have you seen any of those documents?
To the best of my own knowledge, it exists.
But it has not been shared with the court in pictorial form or in photocopies the way the Estonian one has been shared. You can take that affidavit of German and see whether your architecture has been displayed with the Estonian has been. And you can also rely on your knowledge. I'm sure you're familiar with the documents before the court. That's why
Yes.
you are a witness.
Yes, I'm familiar.
Yeah.
But I'm saying from the best of my knowledge, I didn't actually see the architect of the image.
But that's why you are the. Okay. Moving very fast forward, I am seeing that you say in paragraph 6, the government did not just cut and paste the system benchmark, but you carefully selected various desirable attributes and the customer. Which are those desirable attributes? Say of the Estonian, of the whatever.
And some of the attributes that we picked from Estonia and see the security servers. Okay, we also picked the heterogeneous environment in delivering of the services.
I will help you so that we go faster by asking you directly. I am seeing in page 227 of Jerome King's affidavit, point 2.4, data sharing, privacy and data protection. And you found in Estonia, government agencies and private sector were doing data sharing. Did you consider that as a desirable attribute?
Yes.
So, is it possible in NIIMs to share data with the private sector?
Up to certain extent,
Is it designed to do that?
it is started, our system is designed to share data with the private sector. More by
Seeking information,
seeking information
specific information.
and then authenticating. Once it authenticates, it can't yes or no.
Okay, just answering queries.
Just answering the authenticity of the individual. Just to assist in authenticity of the individual.
Authenticity of the individual. Okay, let's go to 228. At the top there, the last bullet at the top before the Estonia Excel. Did you adhere to specific security standards set by Information Systems Authority and the EU standards? Because you have, in this report, there's a lot about EU standards and UK.
Yes, it is within.
And is it true that those standards demand a data protection regulatory and legal framework? In other words, that you require laws for data protection.
Okay, for me, I think what we did is the best practices of developing this technical aspect of it.
Okay, because, okay, I'll take that from you, because I've seen here also that, let me get to the paragraph where you say you use the best technical systems, and I wanted to know, paragraph 32, that you use sufficient technical safeguards. Would you know whether your ministry, you're an assistant director, so you're a very senior person, immediately below, 2 stages below the principal secretary. Therefore, you would know things that are going on. Did you also put sufficient legal safeguards?
Oh, not precisely 2 stages. No, not 2 stages. A bit lower than that.
Okay, but senior enough to know what is going on.
Yes.
Yes. So did you put sufficient technical safeguards according to you? Did you also put sufficient legal safeguards?
Okay, as a ministry, I think for us, the under technical issues to do with the legal and policies, and normally run by the business owner, who in this case is the Ministry of Interior.
Isn't it your ministry that prepared the data policy and the Huduma bill, which is annexed to the
Okay, the data policy do exist, and
in your ministry?
yeah, that one I'm aware of that, and
They generated a data protection law.
yeah. The bill that is currently
Pending in Parliament. So it is fair to say, to conclude, that although, as you say, you may have put sufficient technical safeguards, you never put sufficient legal safeguards because they are not in place yet.
the safeguards we put them because they are listed by Aadhaar acts that exist.
Other?
Acts of
If they indeed address them, why would then the government do something unnecessary like proposing a Huduma bill? Would you act in vain?
I think data protection is about the entirety of it's not about one system. That's across all the systems and computer and computer usage. So in this case, the NIIMs or the NIIMs there is about the human number, but data protection is cuts across both public and private sector.
When you developed this policy and the best talk about the best practices in this report, you are aware of all the other existing laws, isn't it?
Yes.
Yet you found it necessary to propose a comprehensive data protection law with a data protection office of a data enforcement officer.
Precisely, the dynamics in technology right now demands that many of these hacks are put in place just to cushion the dynamics that are happening in the world.
I'm appreciating, but also noting that you have brought into effect the human registration before finishing with the technical, with the appropriate legal safeguard, which is captured in your report and in the best practices.
From my knowledge, I think Ruma was the project Ruma was premised on other existing hacks.
Okay, I'll move from there. Your para 33, how can a citizen like us, or even the court, ascertain the existence of special technical safeguards to protect children? Because you say they're there. How can we ascertain?
Let me say, Ruma number is an advantage.
I'm just asking the technical safeguards.
The technical safeguards that have been put in place when it comes to the biometrics for children who only pick up under the age of 6 and not at the age of 0. At the age of 0, when they are born, it does by data about the parents and the political government and so forth.
Thank you. That's about it. But as far as the technology goes, would you be able to give us one special technical safeguard that is specially designed for children, the way your paragraph 2 is claiming?
Maybe you could assist me by probably giving me a specific issue that.
No, you are the technician, not me. You are the technical person. You have said in the circumstances outlined, there are sufficient technical safeguards that regulate collecting and processing of data. That is really actually. As regards children's identity data, additional special technical safeguards were incorporated. I just wanted to know those special, at least one of those special technical safeguards regarding children.
Well, I think I've already seen the both not happening
Until they attain 6.
until they attain 6 years or 6 years.
Yeah, which I don't think is technical. But carry on.
So basically, I think it is about that, and then we'll see when their children are born. Is ensuring that they are registered. Make it.
Now, okay, if those are the technical safeguards you can give us, I'm okay with that. The other thing I would like to know from you is that what, in your view, the safeguards that safeguard everybody's data, the ones you have collected, are only known to yourselves, the developers, and a few people in the news. So, in other words, you're just telling us, trust us. We know what we are doing. We will not tell you what it is, but just trust us. We'll take care of it.
I think government is a custodian of so many data. The human number is not new because they have data that exist about all of our various agencies in Kenya. In terms of security, issues are being raised about security of human number and security of data starts like that.
Now, you are familiar with the Constitution, and especially Article 10 that gives the public or citizens the right to participate in processes that affect. If you then don't give us even the minimum information about the safety of our data, about the architecture, how do you expect the citizens to participate?
The architecture of the ICN exists somewhere, which always be provided.
So they can be provided.
The architecture of the data can be provided. The level of architecture does as you see in the Estonia case will be provided.
Would you be surprised that your senior stages cannot?
There are two levels of architecture. What you see in the Estonia case is just high level.
Yeah, but it enables those who are technically savvy to understand the inbuilt protection, the inbuilt safeguard.
Let me say that what you see in the Estonia case is just a guide of how the data sits, wherever it sits. But the nitty-gritties of this data is now the higher level that cannot be provided in terms of security. By the high level, it's something that I can even put across in the court, because there is the issue of the infrastructure which is there, the application that is there, and also the users. It's about that.
You are very generous, Mr. Muridi, what you're offering that you can share the highlights. I'm just wondering, did you share with the public that high level, just to give them a glimpse so that they can understand what is going on? Has it been shared to your knowledge? And when I say you, I mean the ministry, not you personally.
The architecture of with the technical officers, the architecture has been shared.
With the technical?
With the technical,
Yeah.
it's shared.
With who?
The technical FBAs is shared.
They are shared.
Whoever wants, okay, the issue of sharing has never arisen.
That's a better answer because I was wondering where you share. Now, the almost last question. 16, you are telling us that the data capture kits were manufactured by Idemia to Otimovo. You are there?
Yes.
And that is correct. You've also been told that by your team. I just wanted to know, are you aware that Otimovo to Idemia to Sapa was recently blacklisted by our academy as a contractor?
That was the corporate domain of our part.
And then finally, if I want to adopt my colleague, finance. I think that was already sufficiently answered by the first moment before you, so I will, that's the end of my examination, but there are questions remaining which Mr. Bashir will complete.
Bashir will be aspirant and he
I will do my best. I don't have as much experience, but I'll do my best. Good afternoon, Mr. Ray. I'll go straight with one of the key issues that the petitioners have raised in this case is the issue of privacy right. And you read their document, right?
Yeah.
And you responded to if you refer to the data capture form, have you seen the data capture form? Which was being used for enrolling people. The second page, there is at the very bottom, there is a disclaimer. You see? Disclaimer. We got testimony yesterday from Dr. Karane Kibicho, who is the administrator of NIIMs. He said that that was to enable sharing of data between government agencies, correct?
Yes.
And he said that it was basically a form of consent by the person giving the data. That the person giving the data is giving the consent that this information can be shared. Do you agree with that position?
I think it is about generation of human number.
At the very bottom of the display, can you read it at the bottom? Display, the fact is, I understand that the information may be shared.
Yeah.
The last sentence, can you read that?
Yeah. Understand my information will be provided to unauthorized government agents.
Yeah. We asked that question to Dr. Kibicho, and he said, this is sharing of data with other government agencies. Do you understand that? Yes. And he said that the person giving the information is giving their consent through that statement to have this information shared. Do you agree with that position of Dr. Kibicho?
I do agree because it's for that purpose.
And he's the administrator of NIIMs.
Yeah, for that purpose.
So, one of the things that you talked about, you said, is you mentioned Estonia, you have done it several times, Estonia, right? And I presume you mentioned to show that you did enough benchmarking and checking other things, right? Are you aware that there must be judicial consent before data is shared between various agencies?
I think the government has been sharing data.
It's a straightforward question. Are you aware in Estonia, before information is shared, there must be, you come to court and get that consent from court? Do you know that?
No, not aware.
Do you think such, because Estonia is a good model that you look at, do you think such an idea would be good?
For government agencies,
before information, private information is shared between various agencies. And you also mentioned private, my learned senior was questioning about private institutions as well, and you said the system is capable of sharing information privately. So before information is shared, do you think getting the court, just like in Estonia, would be a good idea?
for government entities,
So you say that it's not a good idea.
it's not a good idea.
But you don't know what happened in Estonia. In paragraph 27 of your affidavit, you stated the content, we talked about data minimization.
Yes.
And if you don't mind reading that paragraph.
That the contents of the said national master plan is limited only to personal information that is Christian privileged and no more.
Can you stop there? That it must be limited to information that is and this is very important. You can refer to paragraph 27. The contents of the said master population register is limited to only personal information that is sufficient to uniquely identify an individual and no more. It's done by that position. And you go on, you say these principles of data minimization and purpose limitation have been incorporated into the architectural design of NIIMs. Right? Now, if you refer to the data capture form, which I showed you before, you see, it has information on other things apart from limited issues of the identifier. Right? Correct? That's the information it needs. The data capture form. You see that?
Okay, I need to explain this.
No, does it have extra? Because I'm going to try and move faster so that you get your chance in your council. Does it have extra information?
Yeah, it has.
Yeah. What are the kind of information it has?
The extra information it has about this is agricultural activity, culture, employment, environment. This kind of
So it's not limited, it has extra information.
I need to explain this.
Several of the, you get the chance, go ahead. Several of the respondents, witnesses, and experts have testified in this court. And they have said that there is need for more data in order to make the system even more accurate. Do you agree with this position?
From my knowledge, the data capture is
it's really, do you agree that more data is required, or you still stick by this position that less data is required? Just a yes or no.
This data is sufficient.
I'm not asking you whether this data is sufficient for you. I'm asking you, the witnesses have testified from your side, your bosses and other people. They have said, we need more data to make the system accurate, right? You are saying we need minimal data. So who do we go? Right.
It's upon the court to decide by it has an expert, technical expert. My view is this data that is
okay. We'll move on. I think I will explain. One of the things that has also been contention, and they have also included in the issue, you're familiar with?
Is more please how to make DNA. This one.
You've not met DNA anywhere with regard to your work.
In this home technique,
I'm asking you, do you know what DNA is?
It's part of biometrics.
It's part of biometrics. Is it there in the registration of persons act?
Okay, I'm not aware.
Okay, DNA can be used for purposes of identifying individuals. You know that? Is DNA an accurate way of identifying individuals?
Experts can tell us it is accurate.
You're not, are you an expert?
I'm not an expert in DNA.
Oh. You do know that, I can move on beyond that. At paragraph 40, okay, I've done it. Sorry about that. At paragraph 40 of the current definition, sorry, not the QS doesn't get it.
Yeah.
The administrator of NIIMs has called it a centralized digital master database. Is that correct?
Exactly.
And there is interlinkage between the master database and the functional database, correct? According to
Yeah, it is correct.
and we've already sort of gone beyond this point that the more data you have, the more accurate the system. Are you aware, Mr. Brady, that according to the Estonian model, Estonia collects less data in the central database and it has no biometrics in the central database? Do you know that?
Yeah, I'm aware of that.
You're aware of that.
Yes.
But NIIMS is different, isn't it?
Means
In fact, we have something called a Huduma number, which is the unique identifier that is present in both the central master database and is present in the functional database, correct?
okay, the unique identifier is only in the master.
It's not there in the
Functional database.
yeah. No, it is not there. All right. The next question would be at paragraph 29 of your affidavit. Yes. You talk about disparate databases that prevent the issue of function creep, correct? In your paragraph 29, I'm referring to one of that.
Yes, that is very correct.
Now, in a centralized master database that is interlinked with the various functional databases,
I need to clear that it's not interlinked.
I'm not asking you the question. But it's not interlinked. You're going back.
The functional database is one we fetch.
The question I had asked you before, and I'll go back again. I said, according to Dr. Kibicho, the administrator of NIIMS, NIIMS is a centralized master database that has functional databases interlinked. And you said that position you agree with. Are you saying now you no longer agree with that position?
Okay, I believe it's a technical terms. Already.
Do you agree with that position? I say yes or no, really?
Yes, yes.
You agree with that position? Now, do you still stand by your position that functional creep does not occur in such a system?
Functional creep is not going to occur.
It's not going to occur in a centralized system with interlinked functional data. It's not going to occur.
It's not going to occur.
And you talk about paragraph 31 and specifically paragraph 31B. You say, because of just what you just said now, the functional data, are you there with me?
Yes, I'm there.
The functional data, such as criminal records, will remain resident in the respective repositories of the institutions that are occasionally linked to NIIMS database on a need basis. Right? You can even leave out the such as criminal records. You can say the functional data will remain resident in the respective repositories of the institutions that are occasionally linked to the NIIMS database on a need basis. Correct?
Correct.
Essentially, what you mean by this is that there will be information flowing back and forth between the the central database, the master database, and the functional database, correct?
There's no back and forth.
What is it?
For such a case of whatever.
I'm just saying, between the, how does the delegate happen? Because we talked about it. It's an occasional link. This linkage is for information flow, isn't it?
Yes.
So there's information flowing between the functional databases and the central database, right?
Yes, to some level, yes.
There's information flowing between the central database and the functional database, right?
The two is to talk to one another.
They are talking to each other.
Yeah.
So there's information going and information coming.
No.
It's information going.
It depends on what information you're talking
Yeah, I'm not asking what the amount or type. I'm asking, is there information going and is there information coming?
There's no information that is being got from NIIMs.
There's no information that's being got.
These are
So let's discuss. You believe,
My lady, I think this experience is talking about. If the witness can be given at least to explain, because you're throwing questions and if you can't get a word out of the mouth before you're throwing it, to be fair to the witness to all of us, the witness
Mr. Bashir, I know you're not tired.
I'm tired.
Just trying to if you are questions direct the point.
Anyway, I've made my point on the information. I don't think I need to grapple anymore. We'd be interested. Maybe because maybe there's a problem with communication. I'm asking the question: is there information flowing from functional databases to the central database, and information flowing from central database to the functional database? I think I cannot be any more clear than that.
There's an issue of there's some communication happening between the databases.
This is what I'm asking. Is it a yes or a no? So that we move on.
It's a yes and a no.
So maybe ask one.
Okay. Is there information flowing from the central database to the functional database?
That is a yes and a no. It depends on the information required in this case.
So then I presume there is information flowing. You're just talking about the type, and I think you want to explain. But it's okay. There is information flowing from the central to the functional database, correct?
In terms of the queries, yes,
Queries
or no.
Okay. There is information flowing from the functional databases to the central database.
Yes, in terms of asking, is this citizen?
Yeah.
For authentication purposes.
So the system, Mr. Muredi, is designed when called upon to respond and give information.
Yes, by not moving records.
Yeah. And that's why we talk about on a need basis, right?
Yeah, exactly.
Who determines this need basis?
The basis is determined depending on the institutional needs.
Okay. Do you have any policy that guides the situations when this need for this communication to happen, this information to flow? Do you have a policy that guides that process?
Policy exists in terms of institutional needs.
I am asking a specific policy that guides that particular sharing of information and the circumstances in which information can be shared between the functional and the central. Do you have a policy?
I'm sure it is covered in one of the yeah.
I'm asking about a policy. Is there any policy that you know?
I'm not
That okay. Are you aware, you mentioned Estonia again, that the Estonian model citizens can request to know from their government all the ways in which the information has been accessed. Do you know that? That citizens can communicate with their government and ask them who has accessed my personal data in a story. Do you know that?
Okay, I'm not sure if I didn't hear.
Do you think Kenyan citizens would like to know how their information has been accessed, their personal information, and by whom? Like Estonia.
I think it is very well run by the Constitution.
So you think it's a good idea? Can you tell us technically or otherwise how a Kenyan citizen can get to know from NIIMs who has accessed the system is personal data?
I think the system has audit law. Audit law.
Audit law.
Whoever tries to access the system has its own mechanism of recording who accessed, what time, and what part of data was accessed.
Yeah. My question is, how can Kenyans get access to that information?
I think we have a mechanism of which we have to probably institution to last.
But you don't know yourself how it can be done.
There are mechanisms of doing that.
Do you know yourself?
Yes, I know those institutions, the institutions.
You know it's through the institutions. You don't know specifically how that the system can do that. That you can say, type this *144# to get information, or go there. That's something what I'm asking for. Do you know how a citizen can do that?
Well, as per now, it's specifically for names.
It's not ready now.
It's not ready now.
Oh. But it's a good idea. Okay.
It's a good idea.
All right. You said in paragraph 31. At paragraph D, same paragraph, 31D. You talk about, therefore, NIIMs would not provide a purported 360 degrees view of an individual's life. You see that? And I think you made this statement in light of your belief in principles. Are you with me there?
Yes,
What I mean now? Okay. You made this statement in light of your beliefs in principles of data minimization and Aadhaar limitation, right?
I think this was about names capturing so much of data. Finances, mobile, so forth.
Yeah.
I think this was based on this because the internet is being captured.
I think we are agreeing that, and you're saying that the principles that exist of, have less data and limit the purpose. That's why you're saying individuals 360 degree view of their lives will not be there, right?
Will not be
there. In current individuals Aadhaar, the one which I've been referring you to, it talks about IPRS. You know what IPRS is?
very well.
If you refer to current individual affidavit at the annexures, specifically on this would be the strategy paper for IPRS, page 17. Yeah. That would be KK3, the big bundle for current individual. Yeah. This is the executive summary of that strategy development area, which you know very well. If you refer to the second paragraph, where the government, you see that? Do you see the fourth sentence where it begins? These problems, or you can even read from the beginning if you want. The government has several new parts.
The government has several despite injustices that the population legislation comes for that legislation, even the necessary duplication of this population of housing can include that and the first problem. These problems are negative impact on government and population surveillance, government administration, and institutional policies.
Continue reading.
Further, there is good utilization of data redundancy and inability to create data from the issue.
You read the part that said these problems have a negative impact on government planning, population surveillance. You read that? These problems have a negative impact on government planning, population surveillance. Correct?
Yes.
This is the strategy paper for IPIS.
Yes.
Can you also refer to the affidavit of Michelle Wambogu Edward? Do you know who that is?
Yeah, that is a consultant.
He's a consultant. And the next part, that's what the David in support of your ministry, correct?
Yes.
Refer to paragraph 19. Like that?
Yes.
That follows that means database is a unique identifier number repository which matches a citizen to all government touchpoints during the life of a citizen. Like that?
Yes.
Paragraph 19, Mali. Paragraph 19. Edward Michelle Wambogu. One of the experts. It follows that NIIMs is a unique identifier number repository which matches a citizen to all government touchpoints during the life of a citizen. Okay?
Yes.
This is what people are talking about from the cradle to the grave, right? And it is also mentioned that the government wants to solve the problem of population surveillance, right?
Population surveillance depends on the context.
It depends on the context. So you do understand that there are serious concerns about government surveillance.
I think the context in which surveillance is put in the strategy paper has nothing to do with the.
Are you aware, Mr. Brady, of the concept of metadata?
Metadata is data about data.
Then you know what it is.
Yes.
You stated in your affidavit that NIIMs authenticates people based on what they are, right? Their biometrics.
Exactly.
So if I want to get a service, I have to go and present myself, correct? Because it is based on biometrics. Biometrics are part of me, correct?
And it depends on which service you want.
For purposes of authentication, you have to present parts of your body, whether it's fingerprints, whether it's your face. You have to present for authentication, correct? According to your affidavit.
Not necessarily.
Not necessarily. And I put it to you that one of the ways in which you stated there's a difference between Estonia and Kenya is that in Estonia, you use what you have, like a card, right? With a pin. But in Kenya, we use biometric because that's what you are, right?
Yes, exactly.
So for the system to recognize and approve you, you have to enter the biometrics, correct?
Biometrics is for the purposes of identifying you.
Yeah, that's what I'm saying.
Not at the other levels of the services.
Let's take an example of how you enter into for the NIIMs system to authenticate you, Mr. Amre. For the NIIMs system to authenticate you, right? That you are who you say you are.
Yes.
You have to use your biometrics, right?
Exactly.
And for you to use your biometrics, you have to go to a particular point where there is a machine which can detect that biometric, correct?
Yes.
For example, a machine that can be like in the airport where you put your fingerprints and then like that, correct?
Yes.
So you have to go to a service point, correct? Where the machine is, correct?
Depends on what service you.
For authentication, I'm only
For the authentication.
you have to be present.
But again, let me say.
So there would be a record of where you entered your fingerprint, for example, the location where you entered your fingerprint in the system. There would be a record of that, correct? Where you entered your fingerprint, that particular point, would there be a record?
That's in the aspect of a functional database. Functional databases of other institutions. But in terms of NIIMs, NIIMs is going to get biometrics once.
Yeah. It's going to get the biometrics once, so that when you come back again, it authenticates you to say that it is what you have in the system and who you are claiming to be are one and the same, right?
The rest of the work is meant for functional databases developed by institutions.
You go to the rest of the work, the functional databases will be used. The central database will authenticate what is in the functional database, correct?
The functional databases will authenticate who you are with what is in NIIMs.
What is the NIIMs? Yes. So there is communication between the functional databases and NIIMs for purposes of authentication.
Who you are.
Who you are. So there is information that in the functional database, which you set, where you have entered your biometrics. Correct?
I think as Ministry of, as part of this interior, what we are doing here, we are doing number the functional databases.
Okay.
So they rely on NDAs.
Okay. I'm just going to move on. You recently conducted a mass enrollment exercise, correct?
Yes.
You used kits to collect this information, correct?
Yes.
The data from those kits, where is it?
It's in one of the government data centers.
It's in one of the government data centers.
Yeah, and there's a secondary backup.
There's a secondary backup. Okay. So the data is not in a system, really, it's somewhere stored.
It's stored somewhere.
And Dr. Kibichi also said you've not done anything to it in terms of cleaning or organizing it, you just stored it somewhere, correct?
It's just sitting on the court process.
From the court. You're waiting for the court process. But the court process, you don't say you can't issue a huduma number, did it?
I think I'm not aware to that.
But you said you're reading the court process. But you're not aware when the court told you not to produce a moving number, right?
Okay, I'm not very sure of that.
You're not sure.
Yeah.
So do you know why the information is just lying there?
Okay. Okay, one is that aspect. Then is also awaiting verification. Like, as the business owner, you know, as a ministry, we always consulted by the business owner. So is this case is
you're waiting for instructions from the individual.
instructions from me.
And the individual has not given the experts in your department instructions on what to do, right?
I know.
Okay. Because you've not built the system and you have not been given instructions on what to do and to take the next steps, you can implement a lot of these good things you've said about data minimization, purpose limitation. You can implement them at this stage, right?
Everything is possible with existing.
Everything is possible. Yes. Amen. You read about a group of people called Luby. Have you heard about them?
I've heard about them.
You read also their investigation.
Yes, I understand the investigation.
One of the issues that has come up in this trial concerning the Luby is something called exclusion by choice. Have you heard of such a concept before?
I'm not aware of that.
Okay. Do you think when you build this system, when instructions come to you in some way, when you build the system, there is an acceptable number of Kenyans that we can give behind?
Because the system does not count time.
No, I'm not asking you about tribe, Mr. Ray. Listen to my question. Do you think there is an acceptable number of Kenyans that we can give out of this?
For what reason?
Can we, I presume you're saying yes, right? Because you're saying we can leave for some reason, right?
I'm not understanding your question.
I'll repeat it. When you're designing this system called NIIMs, can you say some Kenyans should not be on NIIMs?
I think the intention of the NIIMs is to capture all Kenyan citizens, even foreigners.
So you think there is no acceptable number of Kenyans that we should leave out, right? All Kenyans should be on NIIMs, correct?
That's the intention of the system.
And we should do everything to make sure that all Kenyans are on the system, correct?
No.
We should not.
The intention, I'll say the intention.
There is a difference between intention and action. That you can intend something, but you do something else.
The intention of group, yeah, I think I'll be the same.
What have you said?
I'll say it's the intention of the human
Yes.
system is to capture as many Kenyans as possible.
Okay. You talked about in paragraph 15 of the affidavit the cost of NIIMs, and you made a comparison between Estonia and Kenya in terms of saying that in paragraph 15 you say, we read for you, so if you remember. The cost is significantly lower in Estonia compared to Kenya. And by this you mean the cost of NIIMs is higher than Estonia, right? And you give several reasons. You say Estonia has a low population.
Yes.
Do you know how much it costs Estonia to build that system?
Okay, I think when you look at it, when the issues is 50.
It's a straightforward question. How much Estonia's government spend on its system? Give me a figure. I think if you don't remember, you can say.
Before I think we had figures, but I cannot recall right now. You can find out on why we
And
this statement.
when you're making this statement, would it have been better to say, no, in Kenya we're using 9 billion. How much are we using in Kenya? 9 billion in profit, right? Estonia are using this number of billion. To make the comparison, would it have been better to have that?
I think it's some mathematics calculations that went there before
But
put down this.
they are not here in mathematics, right? You do not put them there. So it could even be, Estonia is more expensive than just one.
Well, I think this statement is very precise.
In your affidavit, at paragraph 14, we talk about the safety of data in an identity card, correct? Yeah. 40, that's the previous part. And you simply are saying there that it is costlier to authenticate an individual based on what they are rather than who they are.
Okay. This was about managing assuming every Kenyan citizen foreigners have a Roma number. This was about managing 52 million cards.
It's very costly to issue 52 million cards, right? And even you said something, the authentication of an individual, and this is what you talked about. And it's almost like an expert statement. You said authentication of an individual in a digital environment based on what they have is costlier than based on what they are, owing to the requisite security and design safeguards attendant to such a model. Right?
Yes.
So you're talking about what do you say? Close your mouth and what you say. You're talking about authentication of an individual in a digital environment. You're talking about authentication. The cost is not about the cards. You're talking about authentication, right?
Yes.
So we are together.
Yes.
So you're saying it is more expensive to have a system that is based on cards than a system that is based on biometrics. That's what you're saying here, right?
In the Kenyan context.
This is a statement you make.
Yes.
Based as an expert almost, that's what I'm saying.
It's based on the Kenyan context.
That, and I'll repeat again, and you said you agree, that it is more expensive to authenticate an individual using cards than using biometrics. That is still your statement.
Yes.
You're aware that Dr. Kibicho yesterday, when he was testifying, were you here yesterday? When he testified? No. Yesterday he testified and said, after this process is over, we shall give Kenya a card with a chip. Now he's the, what do you call it? The business owner, right?
Yes.
He is the business owner. You are saying it is more costly for you to go down that route.
This statement was related to the technologies.
That's exactly what I'm talking about.
Yes.
A technology that is based on a card with a chip is more expensive than a technology. And here you're trying to sell biometrics, that's what you're trying to do. You're saying that our system is based on biometrics, not cards, right? And you're saying,
You see, the aspect of biometrics can be incorporated in a card.
is that what you say in your affidavit?
It's about the technology in terms of safeguarding the technology of the country.
Mr. Ray, you even talk about using a PIN authentication as opposed to biometric. You know you said that in your affidavit?
The PIN,
Yes. And you talked about, in your affidavit, you talked about either what you have or what you are. Didn't you?
yes, I spoke about that.
And you're giving them as, now you're saying something else. Previously you were saying they're exclusive. And we in Kenya have chosen the biometrics. Estonia, and this is according to your affidavit, you can say I didn't say that in my affidavit. But in Estonia, they use cards, correct?
We use cards
With pins, correct? With pins. But in Kenya, we're going to use biometrics without cards. That's your statement.
the biometrics, technically speaking, the biometrics can be incorporated in a card where the chip has the biometrics.
Because now you're changing your. It's okay, you can change your statement to say that this can happen. It's not a problem.
I think the business owner was talking about cards. But when this statement was as a result of managing PIN-based authentication.
And what are
PIN-based authentication.
PIN-based authentication? Let's talk about PIN-based authentication. You said PIN-based authentication are less secure than biometrics-based authentication.
Yes.
Did you stand by that?
Yes, it's stand by that.
So you're saying that people who use the ATM cards, which rely on PIN, and we keep one of the most valuable things we have, money, using a PIN. You're saying that it's insecure?
You see, you need to
You're saying
you need to take care of all segments of the society.
yes.
Only a small percentage of Kenya use ATM cards.
Yes. But you're saying ATM cards are insecure because they use PIN. Would rather be using biometrics.
I've not said they're insecure.
What did you say?
I'm saying the consideration of biometrics is taking care of all segments of the society.
The last question. The last question. Can I just finish the last question? Thank you. And it's good that my language has stood up because I remember something he said. Do you know the parable of the blind man and the elephant? That there was a group of blind men and all of them went to touch an elephant. Right? And one touched the tail, another one touched the tail and said, elephant is like a snake. Another one touched the body and said, the elephant is like a wall. Another one touched the hair and said the elephant is like grass. And so,
It was supposed to be a question.
yes, no, I'm wrapping. One of the things that has shocked us in this trial every one of the government staff, including yourself, have his own idea of what NIIMs is. And you're not disclosing information to Kenyans as to what it is. Jerome Uchieng, who's your boss, left that talk a few minutes ago. And he said, NIIMs is a closed software system. You said in your affidavit, at paragraph 2, you said NIIMs has both open and closed. That's not true. Yes. It's okay, you can say it's not true. But at paragraph 2, I can read for you, and the record is really will say that. That some of the programs are derived from open software, whereas some are derived from closed software. The record is true. My point is, you said in your affidavit that NIIMs is a biometric-based system. Yes. Whereas the Commission has said you issue us with card. So would I be wrong to say that you and your entire team are like a blind man? And NIIMs is the elephant that you're not describe.
I've seen for what the business owner spoke about yesterday is a card with a chip that is integrated with the biometrics.
Thank you very much, Mr. Rose. That's all.
I think that is better.
I don't need the body. Mr. Muridi.
Yes.
Just tell the court, you remember when the 40 mobile devices were booked? When did you confront to acquire the OT mobile device?
It might not be, that must have been sometime late 2018.
Late 2018. You were asked whether you know that 40 mobile was banned by Parliament, and you say it was in public.
Yes.
Do you remember when Parliament passed that resolution?
Parliament passed that resolution after the kids had been delivered in Kenya expected. And I think even Mahanga registration was going on.
Which month would that be?
That must have been after April. After April this year.
After April this year.
Yes.
Now, describe to us, you were shown that pictorial presentation on page 227, if I remember, 227, of Mr. Jerome Ochieng's affidavit. Are you there? 100 and 227 and 228. You can see that. I remember you struggling to say this is a high level presentation. Now, just pause there and tell the court that what levels exist in architecture design?
I think technically there are two levels that do exist when we draw architectural diagrams.
One,
That is the high level diagram
yes, and two,
and low level diagram.
high level diagram and low level diagram.
Yes.
What are the high level diagrams?
The high level diagram is just a representation of assisting and to an technical person has very true meaning. By when it comes to technical people, they're able to know that this thing will require 1, 2, 3. It's basically
What are the low level diagram contain? What will it contain?
the low level diagram is very detailed because it talks even specifications and functionalities of what each of the components that required was identified in the high level diagram is supposed to do and how they relate to one another. In addition to this, the low level diagram will always quantify each the components that are required for the end-to-end system.
As between the high level and low level diagrams, where would you get the source code or the algorithm of the design?
I think I need to say when you look at the high level diagram that is here, it has nothing to do with the source code. Because if you look carefully, it's talking about databases. Is not even a place that is talking about it. It's talking about integrated information system. The source code of whatever you see here can only be attached to integrated information system. Because source code is about applications. It has nothing to do with hardware.
So answer my question in one sentence. Where will you find the source code? In the high level or in the low level?
Nowhere.
Not finding anywhere.
Because the source code is even a little below the low level.
Thank you. You have, I think you have your own certificate. Look at page 109. So 109. That is the form, the data collection form. Are you there?
Yes.
Please look at the last sentence in the disclaimer, pointed out to you by both Senior Counsel Martha and Bashir. Says, I understand that my information may be provided to an authorized government agency, correct?
Yes.
So this relates to interagency or interministerial sharing of information.
This relates to government agencies.
Not third parties.
Not third parties. It's government agencies.
Could I request the council can do less of lead?
Thank you, Maria. Thank you. Thank you, everybody. You were asked whether the data capture form, requires extra information, more information than is needed to identify a person. The answer was okay. Please explain why that is so.
this data is the data capture form is like this.
You have more information than is required to identify a person. Correct? You say yes. I'm asking you the question. Why is that so?
Okay, I think why it is like this, the exercise of human legislation came around when many government institutions were about to collect data. For example, when you look at the data on agriculture, the Ministry of Agriculture will then do a similar exercise assessment on farmers. And look at on the cost. I think it was decided that these data can be collected together with the person's data. So that is where you can see some of this information. Yes, yeah, it was for the purpose of cutting costs and consolidating efforts across government agencies.
You pointed to the strategy paper in which reference was made to government surveillance. You remember that?
Yes.
And you were struggling to explain the context in which that government surveillance is happening. Do you know explain where the context?
Okay. The IPS came around the 2005. And again, this was a time when many of government applications do not talk to one another. The civil legislation data and the national legislation data could not talk to one another. So we have a case whereby we have implications and then we're not able to check that the interagency data. And in my view, I think that surveillance that is talked about in that strategy is about ensuring that the government goes who are its citizens.
It is not unless you have a witness we are down with that before.
Ask you. Thank you for coming, for looking evidence. So we can release it. When we were discussing just the witness this time, there were two proposals. The one by the petitioners was prepared to move forward that parties file their different submissions or even a slightly longer period and longer period. 3 days. Then Mr. Guerrero proposed that parties simultaneously file submissions. Therefore, we are giving raw material. We are given a time for highlight. Now the bench would want some amount of highlighting in what the issues have been testified upon. It was to declare that we have some of the so I guess we are looking for this very to either that or we
will settle for the shortest time possible. We would settle for the shortest time possible. So 3 days, this being a weekend, would take us to Wednesday, Tuesday, for highlighting, and we don't wait on each other. We file simultaneously and we come before you for highlighting.
So simultaneously 3 days and highlighting after 3 days.
That would be fine with us.
The feedback I get from the team, remember I said to consult, the consensus is, as happens, the usual practice, the petitioners go first. Within those 3 days, let them service. We will also, within the shortest time possible, respond to their submissions and then we come and highlight. I think it is taken that way. Otherwise, if we don't have the opportunity to respond with submissions, then the overall highlights become too protracted, lengthy, and so on. So, as we did in petition number 163, where we would go first and the petitioners would respond. So, similarly, let them go first, say by, you said Monday. You said Monday, and then choose whatever time is in between there, before the 14th, we can respond and then come and highlight. 3 working days. So it is the Tuesday. Then we have Tuesday 8th, then we have 9, 10 is a public holiday. We have Thursday, 11th, then Monday is there. No, but the 14th is the 14th. Have it work with the 14th as the hearing?
So this time,
I think that we'll have to do that. We don't want to inconvenience the bench. So we can file by 14th, because we'll have to work over the weekend, the holiday, and so on. As early as possible, if you're coming to INC at 10, the submissions will be on record.
I think we should not protract this matter beyond where it is. The bench has been very kind and had us beyond the hours. These are further or supplementary submissions, not the original submissions. And I think we should all go for dates that are next week. Then each of the parties will have read the other submissions, and the highlight then becomes an easy thing. And the court can give us specific time to avoid running over the time.
okay, so
And we could, alternatively, we could all file simultaneously. It gives, it's okay, it's supplementary, but let them get their way. Let's file, go fast. But 3 days would end on Tuesday, is okay. We can file on Tuesday and let them file by Friday. Then we all have the weekend to read each other's submissions when we come before the court on the 14th.
yes. If you file by close of business on 11th, Mr. Again, it will be
Only that the 10th is really not a working day. Let's see what we can do. Let's see what we can do.
So I think we have some consensus that the petitioners and the interested parties supporting the petition file their submissions by 8, close of business 8. That is supplementary submissions limited to the evidence issued arising from the evidence that you have. And the respondents and interested parties supporting respondents by close of business on 11. I'm being reminded also again the so that then takes us to 14 of October for highlighting of submissions, and that would be from 10 a.m. Now, what would need to clarify so that it is not? Yes. Yes.
Sorry, yes, the interest of practice back to
Okay, so let us start. So that basically means that most of things should be petitioners that we will have we will strictly enforce the time limitations once we have
We move for blind. Just one more thing. Because of the time limits, could we agree that we serve each other in e-form to the court, hard copies and soft copy? And I'm saying this knowing that Mr. Regero will be filing on 11th. He has up to the close of business. He needs to serve us. So if we say by e-form, then it is possible to serve everybody at the click of the button. And we will do the same.
And I assume that you have all each other's email addresses.
What we can do to make sure that that is the case, I will undertake to forward all the email addresses to Mr. Regero for my team, and he does the same. And that will work.
We will include that in the directives. So, we are just confirming that before all affidavits have been agreed in the format that we have protected. So you know this before by 14 because we had the visibility. So affidavits submissions that we have all soft copy. I think it will be the confirmed. So I'm sure there are some we don't have. So it's just send all of the
Then another thing, maybe, for purposes of these submissions, we obviously need the transcript of these proceedings. They already indicated that once we provide the flash disk, this can be done. So if we can get the assurance from the technical team here, tomorrow we will send the flash disks and maybe we can get immediately so that we can use the proceedings for our submissions.
transcribe type for the audio because the transcribed type proceedings that might take a bit of time given
So we're gonna get the audio recording.
Try and get the audio record and maybe again the record once we have started.
Okay, we can work with whatever the court has. But at least the audio we can get with even tomorrow now that we have closed.
I'll try and see because we need to communicate that to the ICT. So that will require tomorrow, let's say by Monday. So then, those are the directions. We'll put them next in text form, but basically documentary submissions for the petitioners, close of business on 8, by the respondents, close of business on 11, in both hard copy and soft copy for the court, initial or advanced copies by soft copy to the parties as the process of service from by 8 and by 11. Then you will share your interviews. And the hearing will be according to 10. We will have according to the audio recording. So we thank you very much for your patience during the hearing, for your cooperation, Mr. Rashid. I'm sure you learned something about direct questions. So the next year it will be much easier for you. So we stand adjourned until 14.
We also thank you, my lady, on behalf of this side, the bar, for the patience with which you have had us, you have sacrificed, you have sat beyond hours. We don't take it for granted and we are very grateful. Thank you very much.
The right.